Our next case is Milne versus Robinson. This is a mini oral argument on the application. Each side has 15 minutes. Ask that you keep track of your own time, and you may reserve 2 minutes for rebuttal. You got it.
Justices, may it please the court. I am Matt Klakulik on behalf of the plaintiff appellant Rebecca Milne, who is the personal representative of the estate of her dead daughter, Riley Robinson. I'd like to reserve 1 minute for rebuttal, please. Here, the trial court erred in granting summary disposition pursuant to the Recreational Use Act and abused its discretion in denying plaintiff's motion for leave to amend the complaint to assert a claim of owner's liability pursuant to 2116 I-5 and 2112 A-2. And the Court of Appeals likewise erred in affirming that decision. I ask this court to grant the application in reverse and remand. The owner's liability statute does not irreconcilably conflict with the Recreational Use Act as to the appellee's liability for the decedent's injury. This court recently found that ziplining does not come within the or any other outdoor recreational use or trail use catch-all provision of the Recreational Use Act because that activity necessitates the landowner's installation of ziplining equipment on the land, in other words, equipping or provisioning of the activity, rather than the activity requiring nothing more than access to the land or, in some cases, that recreational users bring equipment with them to engage in the activity or use. Likewise, liability for being the owner of an ORV that the owner provides to a licensee or guest does not come within the activities covered by the Recreational Use Act because the owner has provisioned the equipment and is liable for being the owner of the equipment, not for being the owner of the land or for the underlying activity. In such a case, as in this court's recent Rott decision, the activity did not merely require access to the land or that the recreational user bring the equipment with them. And this is a narrower basis for reversing than the alternative argument that the statutes don't conflict because the legislature extended the limited immunity of the Recreational Use Act to owners, tenants, and lessees because it is those persons or entities whose possession and control over the land renders them liable under traditional common law principles applicable to premises liability.
You cited to Rott, which obviously is the ziplining case. Isn't this case different? Because there's really no debate that off-road vehicles are definitely covered under the Land Use Act, correct? I understand there's a dispute here between owner and premises and all of that, but as a whole, isn't it different than ziplining because that's not listed, that's not, we found that's maybe not part of the statute. But in this instance, off-road vehicles are definitely normally covered, aren't they?
I would say that, yes, ordinarily you would have the ORVs be covered under the catch-all provision. They aren't specifically mentioned in the itemization preceding that catch-all provision, but what I'm relying on Rott for was that if they had brought their own ORVs with them and crashed, then there would be the limited immunity under the Recreational Use Act, but that's not what occurred here. Here, the owner of the property, the grandfather, provided or provisioned his new ORV to the grandchildren for their use, and in that manner, they were then able to engage in the ORVing, and so in that manner, it comes underneath the Rott.
So the Recreation Land Use Act, I think this is a challenging case. I think you both have strong arguments. One of the things I'm struggling with is the Land Use Act. It seems to me was the intent that you can have a bunch of friends over to your house and they can use your land, but they also, maybe ziplining accepted, but they can use your stuff that normally would fall under the Land Use Act. And I understand you're making a different argument that would parse out sort of anything that's a vehicle that's owned by the person inviting everyone over. Is that correct?
Yes, it's where they provide or provision the recreational activity that then takes them outside of the Recreational Use Act. The legislative intent of the statute was for landowners who have vast tracts of land to open it up to recreational activity, not that they then host and provide the means of the recreational activity to their guests.
But why, if one of the purposes of the Recreational Use Act, or the RUA, obviously is to encourage landowners to invite people on and use their property for recreational purposes, right? And I get the argument that that purpose is furthered by perhaps limiting their liability, their premises, or their liability as a premises owner to only acts of gross negligence. Why isn't that same purpose fulfilled by limiting any of their negligence, whether it's premises or active negligence, to gross negligence? And in contrast, there are a number of other states that have their statutes specifically say that it applies to the duty to keep premises safe, or keep the land safe, or, keep the premises safe. And in contrast, Michigan statute doesn't limit it to premises. So it's not necessarily limiting their liability in total is still consistent with the purpose of the RUA, isn't it?
I think that the Duffy decision, which found that someone who was granted a license with regard to the use of the land, and they were found not to be an entity who was subject to the RUA because they were not an owner of the land, they were not an owner, a lessee, or a tenant, which are the three terms that are used in the statute. And the reason that why is because that comes under the premises, the auspices of premises liability, and so therefore they said that the Recreational Use Act is in fact limited to premises liability. And I think that if you were to allow it to apply to just general negligence, you would have all kinds of absurd results, some of which were listed in the briefing with regard to if a landowner was chopping wood and struck someone who is next to him, then he would only be liable if that constituted gross negligence, or handling a
And maybe
firearm.
we agree with that, but if that's what the legislature said is the standard that applies to that activity, why aren't we bound by that? I mean, if we read the Michigan statute, the way in which it's worded, to apply to any cause of action, no cause of action arises but for gross negligence, not just premises, we might agree that that might be bad policy to let people's active negligence be immunized. But is that our decision to make, or the legislature's in wording the statute differently?
It is ultimately the legislature's decision in how they word the statute. I would note that the statute is not worded in the best manner. It's fairly confusing, which allows for this interpretation, including the Duffy Court's interpretation.
Brought this case initially, the allegations were all about the negligence of the landowner, is that right?
That is correct.
Now we're talking about a proposed amended complaint, if I understand it, where you've alleged this owner's liability claim, and also there was a gross negligence count, but you're not pursuing that at this point either, is that right?
That's correct. We chose not to appeal that aspect of the trial court's denial of the motion to amend the complaint. We're only pursuing the seeking leave to add an owner's liability claim.
The proposed amended complaint appears to me to be somewhat incomplete and legally flawed, because it does not allege that the operator, doesn't even say who the operator was of the vehicle, much less that that person was negligent in their operation of the vehicle. Is there a reason why those allegations don't appear in the complaint, or can you address that? If I understand the owner's liability statute, it's a vicarious liability statute where the owner is liable for the negligence of the operator of the vehicle. Is that right?
That is correct, although the operator of the vehicle need not be named as a defendant. It's a standalone claim.
Oh, but it says the owner of a motor vehicle is liable for an injury caused by the negligent operation of the motor vehicle, whether the negligence consists of the violation of a statute or the ordinary care standard required by the common law. It seems to me to plead a valid claim, you'd have to at least allege that the owner was, or that the operator was negligent, would you not?
I believe we do, yes, and if the proposed amended complaint that was attached to the motion does not state that, then we'd certainly correct that before filing it. We're alleging that Riley Robinson's sister Peyton's negligent operation of that motor vehicle is what resulted in Riley Robinson's death and Larry Robinson Sr.'s liability for owner's liability, and you know, we would make sure that that is laid out in the amended complaint.
How was she negligent in the operation of the vehicle?
Well, she offered testimony that this was a brand-new ORV, that previously they had been driving an ORV that that required you to shift gears, and that this was an automatic transmission, so that whereas before they had kind of a governor that they would only hit a certain speed before you'd have to shift gears, which they wouldn't do, this one had an automatic gear shift, and she offered testimony that it flew. It went extremely quickly, and it's pretty clear from what transpired here that she was not using adequate care in operating the vehicle and went too fast and lost control of it, resulting in the injury.
All right, thank you, counsel.
This court also asked that if the statutes are found to conflict, how do we resolve that? And while we don't believe they do for two different reasons, when two statutes or provisions conflict and one is specific to the subject matter while the other is only generally applicable, the specific statute applies. And the appropriate framework for determining which provision is more specific is to consider which provision applies to the more narrow realm of circumstances and which to the more broad realm. The Court of Appeals held in this case that the RUA is more specific statute as it deals directly with the potential liability of landowners when other persons recreationally use their property with ATVs, whereas by contrast, the MVC, the Motor Vehicle Code, applies to all motor vehicles in all places and circumstances. And I strongly disagree with that. We're seeking to proceed under the owner's liability statute of the Civil Liability Act of the Motor Vehicle Code, a much smaller section, yet they would say the entire Motor Vehicle Code, look how broad it is.
Doesn't the result of this general versus specific canon, the result is dictated by how you frame the question of what's what it applies to? And I think maybe we're struggling for this sort of square peg in a round hole. This isn't, I get where that applies, where you have a statute and another statute that is a subset of that statute, or they regulate the same thing. I get it has application there. These don't relate to the same material, and you can, or the same, issue, the same topic. So depending upon how you describe what is being, or how you characterize what is being regulated, or what is the intent, the purpose of the statute, or what have you, dictates which one is general or more specific. So, does it really help us much at all in that canon? And if it doesn't, if you agree with me that you don't think it does, how are we supposed to look at it otherwise? How are we supposed to look at these two statutes that don't relate to the same thing and figure out what the legislature, we can figure out what the legislature meant with each of them. How do we figure out what the legislature meant when both of these potentially apply?
I unfortunately don't have a grand solution to that statutory interpretation issue. I do have one specific to this case.
Okay.
Which is that, for example, the NREPA, the Natural Resources and Environmental Protection Act, of which the RUA is a part of. It was adopted or brought into that in 1995. It has a subsection that specifically addresses ORVs and defines ORVs and says that risks associated with that sport, insofar as dangers are inherent, you can't sue for that. But they specifically exempted negligent acts, so you can proceed on negligent acts. Whereas the RUA here makes no specific mention of ORVs. It would come within the catch-all provision at the end. It deals with an extremely broad, it has an extremely broad scope and can deal with such things as, and the catch-all provision could also have like horseback riding or mountain biking or cross-country skiing. So under that existing analysis of which is broader and which is more specific, I think it's clear that the Owner's Liability Act and the facts of this case is the more specific and the more tight in scope, and so therefore it would prevail over the RUA here. Could I preserve a minute for my rebuttal?
You have 36 seconds.
Sorry about that noise.
I was going to say good morning, but I see it's just become noon. So good afternoon, Your Honors. Pleased to be here. I'm Daniel Saylor, appearing on behalf of the defendant appellee, Larry Robinson, the owner of the land in question and the owner of the ATV in question. I want to mostly focus on application of the RUA to these facts. I frankly originally thought that when you issued your order identifying your 3 questions, that the first one was a bit of a no-brainer. Well, obviously, read the statutes, they both apply. Let's move on and analyze these next 2 questions about how you resolve the conflict. But I think most of the pushback we've gotten is on the question, does it RUA even apply? The plaintiff's thesis is that there is no conflict between the RUA and the owner's liability motor vehicle statute, because the RUA does not apply to a claim under the owner's liability statute. But that's not a reason, that's just the conclusion they want to reach. The real question is whether the RUA, never mind the owner's liability statute for a minute, whether the RUA applies to our facts. And as Justice Kavanaugh, I think, fairly alluded to, by its terms, it pretty much clearly does. The claim here is for injury to a person. That person is on the land of another, check, there for the purpose of engaging in recreational trail use at the time described, of the kind described in the statute, that's check. No consideration was paid, check. So absent gross negligence or willful and wanton conduct, no cause of action arises against the owner, tenant, or lessee of the land. By its terms, it applies. So the plaintiff's position requires that they say, well, by implication, it doesn't apply because it only applies to premises liability causes of action. Of course, the statute doesn't say that. Where does it come from? Where does that notion come from? Well, the plaintiff would suggest that it comes from the fact of, look who's being identified for the protection, owner, tenant, lessee of the land. These are people who are the ones subject to premises liability cases, that type of liability. It must be that the legislature meant to apply this to premises liability cases only. But that's not a fair inference at all. The reason why, I think it's fairly obvious that the legislature elected to extend the protections to those in possession and control of the land is because those happen to be the ones who are able to open private land to the public for use, for recreational use. That's why those are the ones identified. And the deal was you can't force people to open their land, so all the legislature could do was incentivize them to feel free to let people use their land for these recreational uses. And the deal was if they sustain personal injury in that process on the land, you are not subject to liability for personal injury, absent gross negligence or willful and wanton conduct. And
Mr.
secondly,
Saylor, can I ask you, so let's assume that we were to agree with you that both the RUA applies, and the owner's liability statute applies. One says for the same conduct you only need to prove negligence. One says you need to prove gross negligence in order to sustain your cause of action, right? So they both apply, and we're trying to figure out how this works, right? And the Court of Appeals looked at it, as I indicated earlier, which I don't believe is really an applicable canon to this of the general versus specific. And as an alternative, you suggest in your briefing that we should look at it in terms of one is liability imposing and one is liability restricting. And the legislature must therefore intend for the liability restricting one to control. Why? Because, I mean, if the legislature is providing a cause of action, presumably that's their intent, to allow somebody to impose liability, and if they're restricting it, I mean, aren't we in the same sort of spot? Like, how do we divine that the legislature thinks that that limiting liability should reign over their own decisions to allow for liability?
Well, I think on that point, I just tried to show by example that over and over and over again, that's routinely what happens, that there's a grant of a cause of action, and then there are situations where even though the grant would apply, so does an immunity or a liability limiting provision, and it is routinely treated as the general rule is there's liability, but the limitation or the immunity granted operates as an exception to that general rule.
Is that only within sort of the same framework of a particular statute, right? Like, or I get, like, even the GTLA, right, limits liability for common law, otherwise causes of action.
No, that's
But here
true.
you have, never the two shall meet except in these weird fact patterns, right?
That was true also in the what is it, Wolf versus Wilfong or something like that. Again, governmental immunity on the one hand, motor vehicle codes ownership liability on the other. Same thing. The broad grant of liability to against the owner of the vehicle that was negligently operated, but in this instance, governmental immunity applied that operated as an exception to the grant of liability under the owner's liability statute.
Is there relevance to when these statutes?
Yeah, that's also another point.
And the failure to amend or like say, or there is no specific exception.
Right. That's another good point. I basically identified not just you got to look at which one's more specifically applicable and broadly applicable. I think that weighs in our favor, which I can explain why. I think separately, because routinely the grant of liability is treated as a general rule, a liability limiting provision as an exception to the general rule. And also, as we point out in the brief too, the Motor Vehicle Code's ownership liability provision in its basic form, and it's in one form or another, has been around essentially 100 years. And RUA, for half that time, and even then it started off only, protecting, applicable to things like fishing and camping and hunting or something like that. And more recently, they specifically started including references to motor vehicles, motorcycles, other trail use activity of the same sort. And yet, they don't add in the statute starts, subject to the subsections below, except for as set forth in the subsections below. They didn't add one to say owner's liability will still give a cause of action.
But what do we do with the fact that we're not supposed to presume that lack of action on the legislature is an intentional choice, right? Like,
Well,
their
it's
failure
either
to
nothing-
include this or amend it doesn't mean that they intended not to, right? The legislature speaks through their acts. So what do we do? I mean, are we sort of assuming that to be the case? Well, it wasn't amended,
It
but
just strengthens the fact that the text of the RUA, by its terms, would apply to exonerate the owner. And that it would apply even to whatever cause of action. The very fact that owner's liability already existed and they didn't do anything to exclude that from the scope of the partial immunity, it only adds to the importance of the broad, unequivocal language of Section 1.
would you agree would your client potentially be liable if, assuming we agree with you that the RUA applies or is controlling,
Controlling, okay.
is controlling, would, if there is gross negligence, that your client is still potentially applicable? Or is it that it only, right, I mean, so in the provision of the vehicle?
No, certainly, if, let's say that for whatever reason, let's say that ORV did not qualify as a motor vehicle within the meaning of the ownership liability statute. He still loaned the use of the ORV to the granddaughter, and we still have common law negligent entrustment. If that was negligent in giving the granddaughter use of that ORV, they would still be protected unless that negligence rose to the level of gross negligence. Then there would be liability.
I see.
And let me go ahead and just make my point, because I don't necessarily agree that to say one is more specific and the other is more general can be answered either way. It just depends on how you approach it. Here, like the lower courts, both of them, I think it's apparent that, in fact, I mean, naturally, the plaintiffs have to argue it the opposite way, but I think it's very clear that the RUA is a far narrower statute. It applies, it defines a very a unique, specific set of elements to apply, and it applies on all fours to our facts. No strained constructions or stretching the elements at all. It's right on point. It applies by its terms. Ownership liability, on the other hand, applies, it's a very broad-reaching statute.
But what if we define the scope of things to be covered as liability on recreational land? RUA applies to all liability that might arise on recreational land, and the owner's liability statute would only apply for liability
One
that
part of it.
arises out of the provision of an ORV, as opposed to, I don't recall if it was your brief or the amicus brief that defined it as just liability, right? I mean, so how you sort of define what the scope of we're regulating sort of, to me, lends,
Well, what
steers
you're
you down the
saying
path.
Is that, suppose they both apply, and you're zeroing in on what do they have in common? Well, they have in common that both apply to the motor vehicle component of this incident. But like I say, it's squarely within the focus of the overall RUA, whereas the ownership liability, the only reason it applies here is due to the very broad reach of the motor vehicle code and its ownership liability statute. It generally applies to all trucks and all cars and motorcycles and driving across the roads and highways of the state. But because the broad reach, it can even apply over here in the periphery when someone's driving across a field.
The
So it
RUA
does
applies to
apply.
all activities on recreational land, but the motor vehicle code only applies to recreational activities that involve a vehicle that was driven negligently with the owner's permission. I mean,
Right, but, well, yeah, so, I mean, in that regard, you can reach the end depending on which one you say first. But in order to determine which one applies with more specificity versus more generally, I think it has to be appreciated that ORV, that the fact that it applies at all in this, that the fact that the owner's liability statute applies at all is because of its very broad scope.
or maybe it's just okay to say that broad versus specific doesn't apply in this case, or it's not helpful. That canon, right? Like, it doesn't actually help us arrive at the goal, which is to figure out what the legislature intended.
Well, I think it's consistent, and it's 100% consistent with the notion that you've got a broad declaration of a cause of action for owner's liability, and then where you've got different provisions such as the Governmental Immunity Act, this one, where it's a liability limiting situation, and here, under these specific circumstances, the person's going to be immune from this broad stated liability. That's detailed in the brief. How much time do I have? Do I have a little bit left? 54
minute.
seconds, it looks
Minute.
like. But as I say, the facts of the RUA and the very nature of the RUA and the nature of the statute has to be recreational use, whereas the ownership liability statute, it doesn't care what kind of use it is, commercial, private, recreational, doesn't matter. Has to be for trail use on the property for the RUA, whereas it can be on any road, anywhere, any field for the owner's liability. As I say, that's in the brief. I wanted to make one more point about this idea that premises liability would be, that the legislature only intended premises liability to be within the scope of the RUA. And again, you referred to this, Justice Kavanaugh, with regard to other states that actually do refer to arising out of condition of the land. Well, this very provision, if you go down to sub 5 and sub 6, the legislature knew how to describe premises liability action. It's right there. The elements of the cause of action are in sub 5 and in sub 6. So they know how to do it, and they clearly did not make any kind of limiting scope of the type of cause of action. A cause of action, it doesn't even ask, does the cause of action arise from or based on a condition of the land or the ownership of the land? It just says a cause of action does not arise, period, if it's for injury to a person, and provided the rest of the statute is met, and it is. So frankly, I think the Court of Appeals got it right, and the court can simply deny leave to appeal.
Thank you.
Thank you.
A couple brief points. Brother counsel was talking about common law negligent entrustment. That is not what is at issue here. We're talking about owner's liability. It's a separate cause of action. And as the MAJ amicus brief notes, either the RUA is not limited to premises liability causes of action, which contradicts Duffy, in my opinion, and it makes it far less specific to this case than the owner's liability provision, such that the Owner's Liability Act applies, or the RUA's application is limited to premises liability consistent with Duffy and recreational use statutes in at least 5 other states, and RUA immunity does not apply. And furthermore, the RUA does not apply, and there is therefore no statutory conflict as to an owner's liability claim where the landowner provides the motor vehicle and thereby equips and provisions the recreational activity consistent with the Rott decision. Neither Robinson Sr.'s ownership of the land in which the ORV crash occurred nor his conduct have any bearing on and are entirely irrelevant and incidental to establishing the proposed owner's liability cause of action. The owner's liability cause of action does not arise against the owner of the land based on his status as the owner of the land, but rather it arises only as his status as the owner of the ORV. And so therefore, I believe the Court of Appeals got it wrong, and this court should reverse and remand.
Thank you. Thank you both. The case will be submitted.